It's been months since Texas realtor Suzanne Simpson was last seen alive. The mom of four vanished without a trace after getting into a fight with her husband, Brad. But was it a mysterious disappearance, or did something terrible happen? I'm Elizabeth Millner with Law&Crime. It's hard to think that a beloved mom would just walk away from her children, her family, her home, her entire life. No one has heard from her in 6 months. Her husband, Brad, was charged with her murder, but now he's hoping a judge will toss out the indictment against him.
The case law is clear that the state does not have to prove how Mr. Simpson murdered Suzanne Simpson. What we do have to prove is that he intended to cause either her death or serious bodily injury.
October 6, 2024, that's the last day anyone saw Suzanne Simpson. That night started out pretty normal. She went to a party, took her daughter to the grocery store, came home, but by the next morning, she was reported missing. A lot went down after Suzanne returned from HEB, like Suzanne calling her mom to tell her Brad allegedly assaulted and injured her. Then a neighbor told police they witnessed Brad and Suzanne arguing loudly. There was a struggle, there were screams coming from the woods near their home. You can only imagine what actually happened. But here's the thing. We don't know the full extent of what happened. An hour later, that same neighbor saw Brad leave his home, then he returned later on. But no Suzanne. She hasn't been seen or heard from since. And it wasn't Brad who reported Suzanne missing. It was her friend. It was only when police contacted Brad that's when he told them essentially he hasn't seen his wife since the night before. For those who actually cared about Suzanne, it was completely out of the ordinary for her not to respond, not to pick up her daughter from school, and to just disappear. Authorities arrested Brad on October 9th, but not for murder. He was initially charged with assault and unlawful restraint. But police say he wasn't the most cooperative with their investigation. Despite not finding Suzanne, officials went ahead and charged Brad with his wife's murder. And the evidence against Brad isn't looking too good. Investigators found a motorized saw with Suzanne's DNA on it, and they tracked his whereabouts, only to find he dumped a large, bulky item wrapped in tarp at a dump site. Again, not looking too good. But authorities still haven't found Suzanne's body, which seems to be the basis of why Brad's defense attorney wants his murder indictment to be tossed out.
We're here today because the defendant filed a motion to quash the indictment. I have that in front of me.
Looking at just paragraph B, I've kind of diagrammed it a little bit as well. So that, in this case, Brad Simpson committed an act clearly dangerous to human life. That is the nature of his conduct, committed with intent to cause FBI. That's what the indictment puts me on notice of. That caused the death. That's the causation element. That the result of the conduct, the act that occurred, the clearly dangerous act, and then your guess is as good as mine, because they just alleged that it's by manner and means unknown to the grand jury. That somehow this act that's clearly dangerous to human life is also, I don't know, unknown. And that's not noticed, Judge. But this discussion about result of conduct and nature of conduct, that's me responding to the state's brief. Ultimately, it doesn't matter for the purpose of determining whether or not I have notice. Notice is the issue, not the culpable mental state. And whether it's a result of conduct offense or nature of conduct offense is immaterial. What I'll point out is the penal code does not define what an act clearly dangerous to human life is. There's no definition from it, and because there's no statutory definition, we're not allowed to put a definition in the jury charge either. So the jury's not going to get to know what an act clearly dangerous to human life, which also means I don't get to prepare to defend against whatever act the state may be alleging. There could be a number of statutory defenses. There could be a defense that it never even occurred, that there's an exception or excuse. But because the state hasn't alleged it, I don't get to prepare a defense to that particular act.
So the defense pointed out the language in the indictment was too vague, and obviously the state disagrees.
Judge, I just want to start by saying the law doesn't reward people for disposing of the bodies of their murder victims. The case law is clear that the state does not have to prove how Mr. Simpson murdered Suzanne Simpson. What we do have to prove is that he intended to cause either her death or serious bodily injury, and that he did in fact cause her death. And I won't belabor that point because it's addressed fully in the state's brief, which was filed on April 1st of this year, and I'll just ask the court to take judicial notice of that brief, which is part of the record in this case. But to just sum up, the manner and means, the how of committing murder or assault are not elements of those crimes. But when we allege an unknown manner and means, we've done more than is required by law. The law doesn't even require us to put that in the indictment. Those are not elements of the offense. We're not required to prove them. The state's indictment tracks the statutory language for each offense, and it gives adequate notice of each offense charge. We've alleged intent, and we've alleged result. We don't have the benefit of a body at this point for a medical examiner to look at and give us a precise cause of death, but that does not prohibit prosecution of this case.
What about the idea that the state can only give you notice of what they know? In this case, apparently, I'm assuming that through your representations, there is no body of the, complainant in this alleged offense. What do you say that the idea that the state can only give you notice of what they know?
Sure. And so take that to its logical conclusions. What other offenses could they indict Mr. Simpson for that they think they know about and they hope they produce evidence of at trial? I mean, what offenses could they indict anyone for that they don't know about now and aren't telling me about, especially in an indictment, but they sure hope to shore that up by the time we get in front of the jury? I mean, ultimately, Judge.
Well, when you say that, when you say shore up, let's say, and I know this is an alleged offense, but let's say at some point the body of this individual, this complainant, is found, then they would have to give you more notice, correct? I mean, when you say shore up, is that what you're talking about?
Well, so in a hypothetical situation where something like that occurred, I would expect the state to either amend or re-indict. Right?
And so would I. So
there would now be new facts, and there would be a medical examiner's report that would allege cause and manner of death as well.
But I'm trying to figure out what you meant by when you said that they can shore up their case as they go. What do you mean by that?
Well, I mean, the state will, I'm sure, agree with me that discovery is not complete in this case, that they're still awaiting on at least 6 reports for the Texas Rangers that I'm aware of. Okay. And so the state is hoping that additional better evidence will appear in those reports. As of right now, I don't want to get into the sufficiency because it's not an issue here, they still get to prosecute a murder if they so choose. It just means that if you're going to do it under B2, you got to tell them more. And if you can't tell them more, don't indict it that way.
So what was the judge's decision? Is the murder charge dropped? Well, it's staying for now because the judge plans to hold his ruling until another hearing. Let's bring on now Texas-based criminal defense attorney Anthony Osso. Anthony, what are your thoughts when it comes to this whole defense's argument when it comes to Brad Simpson's indictment? They say it's vague. It says that Simpson killed his wife by a manner and means unknown. Now, we've seen cases where prosecutors have tried a case without a body, but what are your thoughts on the defense's argument about the indictment?
I think it's a good argument, and I think, from the defense perspective, object to it and preserve error so that if a conviction happens down the road, you've at least laid the groundwork in the event that there's an appeal. Do I think that the judge will grant their motion? Probably not. Like you said, Elizabeth, there are instances where prosecutors have to try cases where they don't have a body and they don't have a medical examiner to actually evaluate how a person was killed. And I think the judge and the law probably are going to lean on the side of a defendant doesn't benefit from the disappearance of a murder he's responsible for.
And, it's been 6 months now. Suzanne Simpson, her body hasn't been discovered. But I want to know your thoughts on whether or not you think the prosecution maybe rushed indicting Brad Simpson for murder specifically. What are your thoughts on, or is the timeline kind of normal in these types of cases where, we don't have a body now yet possibly, but we're just going to go ahead and bring this to a grand jury, hear their thoughts, and they came back with that indictment?
Now, it's an interesting point, and I think I do think it's rushed in a sense. My understanding is that I think a month went by before investigators went to file charges in this case, and I think that there's a lot of independent investigation you can do after a disappearance that you could use to support a charge, and also through that find your manner and means, and maybe find your specific act or cause of death. That way, you're not dealing with these sort of motions to quash the indictment and things like that. So it does seem rushed to me. Investigation can take anywhere from months to years. So they could have probably taken more time.
Yeah. And, as far as the judge, do you think that, say for instance, that he does toss out the murder charge on the indictment, what does that mean for the case kind of moving forward? Does it mean that possibly prosecutors can take that information back, get more evidence, collect more things that they need to prove their case, bring it back to a grand jury. Can they do this all over again if the judge does happen to rule that he's going to toss out the murder charge?
Absolutely, Elizabeth. So they're not in trial yet. They haven't picked a jury, and a jury hasn't been sworn. So jeopardy has not attached, which means that if the case was dismissed by the judge, the prosecutors could turn right around, meet with the investigators, and further investigate, or file an indictment with more specificity, and just re-indict the defendant in this case. So it doesn't mean that they couldn't go forward on charges in this case.
And as a criminal defense attorney now, I know you previously had worked with the district attorney's office
Yes.
as well too, but speaking in the mind of a criminal defense attorney, does it make it easier for your case if the body is not found? Does that make the defense a little bit easier, or does it make it harder? What are your thoughts on, since the body hasn't been found, which is still so horrible to think about, but what are your thoughts on, if this case were to go to trial, is it easier for the defense knowing that investigators still haven't found her body yet?
I think my gut instinct is easier. It's like not having the murder weapon. It's a flashy, sexy fact that the defense can lean on. But it also depends a lot on what your argument is. So if it's a whodunit kind of argument, then I do think not having the body present is probably good. But like if you're arguing self-defense or things like that, you probably want to use certain evidence that the medical examiner could look at, like defensive wounds and things like that, to assist your case. But I think generally speaking, no body probably makes it easier for the defense attorney.
And it seems though, even without the body, that there is a lot of evidence, it seems, and it appears, I should just say that with emphasis there, a lot of evidence against Brad Simpson that we know now. You have the motorized saw with Suzanne's DNA on it. He was caught on surveillance video dumping a large item wrapped in tarp at a dump site. Then you have the couple's daughter come out and say that her father was abusive towards her mom. It just seems like there's a lot of kind of evidence there, even though it's circumstantial, but it seems like there's a lot to kind of point to. You talked about the whodunit, but it seems like allegedly Brad may have done this.
Yeah. Well, and I think, you mentioned circumstantial evidence. A lot of times circumstantial evidence is stronger than witness testimony because circumstantial evidence isn't necessarily subject to committing perjury, right? So it does seem like the state the investigation has put together some strong evidence. If you put it, it's tough to break. It's easy to break a twig. It's tough to break a total stack of twigs, right? And in murder cases, and specifically sort of in these intimate partner violence cases, the law in Texas allows you to talk about the nature of the relationship. So the abusiveness that led up to her disappearance is going to be, I'm sure, a key fact that the state will lean into if this case goes to trial.
Yeah, and it seems like that point will be very crucial, kind of painting the picture, especially for a jury who presumably will have no idea what this case is even about. And it seems that from Brad Simpson's standpoint, you would think that if you are accused of murder, that you would do anything to either get investigators off your case or at least be cooperative, especially when you're dealing with a partner crime where your wife goes missing. And you would think of all things that you would try to at least cooperate with investigators so that way they know, hey, it's not me. But it doesn't seem like Brad Simpson did that in this case. How difficult is it to defend a client who in the first place wasn't necessarily cooperative with investigators by the reports that we've been seeing?
Well, I'll put my defense attorney hat on and tell you that if investigators were investigating a client of mine for the disappearance of someone, I probably would advise them not to talk to the investigators because people's words can be contorted and misinterpreted. And so I understand the general perception might be, oh, well, he should have assisted. But had he consulted counsel, I'm sure any lawyer would have told him not to talk to the police.
And say, the murder charge and the indictment stays as is. What do you think is going to happen next in the case? Is it going to be we're gearing up towards trial? Do you think the defense is going to try to toss in a whole bunch of motions to kind of delay things, knowing that Brad Simpson still remains in a county jail right now? What do you think is going to happen next if the murder charge does stay and the indictment stays as well, too?
A little bit of both, the kitchen sink. It seems like the defense is they're aggressive. They're already filing motions to quash, and the case isn't even a year old yet. I imagine that there's more investigation ongoing and more discovery or evidence being turned over to the defense. So I imagine the state and defense will probably talk about potential offers and plea negotiations, but it's always going to be in the defense's mind of putting their client in the best position, whether that's through resolution or whether that's through motions practice or pushing forward onto trial and trying their hand at a not guilty.
Have you ever seen a case where the state goes to the defendant, goes to the defense attorney as well too, and is like, hey, if you just tell us where the body is, we will make sure that you don't get the death penalty or a life sentence. We'll make sure you get time for parole, maybe if it's 50 years down the line or whatever. But do you think that it's possible an offer like that is made in this case, where maybe prosecutors just go up to Brad Simpson and are like, hey, if you tell us what you know, we'll go a little bit easier on you?
I don't think so. I haven't seen that. They've clearly made the investigators and the state, or the prosecutors in this case, have clearly determined that he is responsible for her death. And so I don't imagine that they're going to offer him leniency at this point for information on where her body is. But he'd be giving them more evidence for them to secure their case against him.
And it seems like if the time were to talk, it would have been, right when investigators were first talking with him and getting information from him in police interviews. And given that it's been 6 months down the line, I'm kind of with you there. I don't see a deal happening. And I'd be very stunned if a deal does happen. Anthony, I want to thank you so much for your time today. Before we sign you off, though, where do you think the case goes next?
I think there's a long road ahead. And I think that the defense and the prosecutors have a lot of discussions in the meantime to figure out how to resolve this case before they decide to put it on a jury trial docket. So, negotiations.
Yeah, negotiations, just waiting and checking to see if a trial date actually gets on the calendar, and if that trial date does happen, whether or not it's this year. Anthony, I want to thank you again so much for your time and your insight into this case. I really appreciate it.
Thanks for having me, Elizabeth.
Brad Simpson remains in the Bexar County Jail, held on a $5 million bail. His next hearing is scheduled for April 29th. Reporting for Law and Crime, I'm Elizabeth Millner.